Your Section 341 meeting of creditors is approaching. So to help ensure a smooth meeting, this video will provide you with instructions relating to that meeting. We'll cover several things. First, who's involved. Second, what to wear. Third, what to bring with you. Fourth, how the meeting is conducted. And fifth, what happens after the meeting. So let's get started. 1. Who's involved? The meeting of creditors is conducted by the trustee assigned to your case. The trustee is an attorney who gets appointed by the court to represent your creditors. The trustee is not a judge, and no issues of law will be addressed at the hearing. You can think of a 341 meeting as a mini deposition, only less formal. So what should you wear? You should dress informally. You don't need to dress up for the event. In fact, we suggest that you dress normally or dress down or casually. That you don't wear any jewelry or other items of value. We want you to appear as ordinary as possible. There are several documents that you need to bring with you. You need to bring these documents even if you've already provided them to our office. They are first, your government issued picture ID. This can be a driver's license, state ID card, or a passport. It just needs to be a government issued picture ID. Second, you need to bring your Social Security verification. This can be your original Social Security card, or if you don't have one or can't find it, you can also bring an original W-2. It does need to be an original W-2 if you're bringing that document. If for some reason you don't bring the Social Security verification, the trustee is required to have you bring it to his office along with your picture ID to verify the information you provided for your identity. So please don't forget. Third, your pay stubs. This is your most recent pay stub. The pay stub that you received just before the 341 meeting. This will be a pay stub that you received after your case has been filed. Each person that filed the case needs to bring their pay stub. If you're self-employed, unemployed, receive disability or Social Security, then you don't need to bring the pay stub. Fourth, you need to bring your bank statement for each account that was open on the date your bankruptcy case was filed. That's the date that we filed your case with the court. The bank statement or statements must be a full statement and must cover the date that your case was filed. You should receive several 341 meeting reminders from us that will include the petition date, so you'll know exactly which date to cover on that statement. To expedite the meeting, on each statement we want you to circle the balance of the account for that date. That would be the balance you had in your bank account so that it can easily be seen. The trustee is looking at the bank statements to see how much funds you had on hand at the time your case was filed. As we've advised you before filing your case, we want the balance to be as low as possible. 5. You need to bring your most recent filed state and federal tax returns. If you haven't filed in the past 2 years, then you don't need to bring them with you. Otherwise, bring the most recently filed tax returns, even if you've provided them to our office. Bring both state and federal returns. When you arrive at the meeting, please get your documents out and put them in a stack in the order we provided. First, your picture ID. Second, your Social Security verification. Those should be on top. Underneath them, put your most recent pay stubs, followed by your bank statements, and on the bottom, the most recently filed tax returns. When you arrive, you will go into the meeting room. The meeting is grouped with several other cases, usually around 8. The trustee will then give an opening statement and explain how he plans to administer the cases. He or she will give you a reminder that any tax refunds or any funds that you had on hand at the time of filing your case are property of the estate and can be required to be turned over. Don't spend any of these funds until after the 341 meeting, and we determine whether any turnover requirement will be issued. The trustee will then start calling the cases one by one. When your case is called, you'll come forward and hand the stack of documents to the attorney present from our office. The trustee will then put you under oath, have you state your name or names for the record, and then you'll sit down and the trustee will begin asking several routine questions. Did you read the statements and schedules and related documents that you filed with your bankruptcy case? Did you sign those statements and schedules and related documents? Are the signatures your own? If you sign the statements and schedules and bankruptcy papers electronically, it is your original signature once you adopted it, so the answer would be yes. He'll ask if you've read and understood the bankruptcy information sheet. The bankruptcy information sheet gives you an overview of the 4 different chapters of bankruptcy. It explains a discharge and some exceptions to a discharge, like student loans. And finally, explains a reaffirmation agreement. The email reminders that you will receive from our office regarding the 341 meeting will have the trustee information sheet attached, so we recommend that you review that document before the meeting. The trustee isn't going to ask you any specific information about the document, he just wants to know that you read and understood it. Then the trustee may ask additional questions about your assets or other aspects of your case. His job really is to see if there are any other assets or non-exempt property that can be taken and sold on behalf of creditors. When you answer questions, please keep your answers as short and concise as possible. Keep it to yes, no if possible. Only answer the question that's being asked. Don't elaborate or volunteer any information that isn't being asked. Finally, what happens next? After your 341 meeting, there is a second educational course that you will need to take. You'll receive an email from our office with instructions on taking the course. Take the course as soon as possible after the meeting so you don't forget. If you forget to take the course, the court cannot issue a discharge and your case may be closed without a discharge. If that happens, we can file a motion with the court to get the case reopened and reinstated so that you can take the course and get a discharge, but there is an additional cost for the extra work, so it's best if you just take the course the first time. Take it right away before you forget. The trustee may issue directives at the 341 meeting. Unless the trustee issued directives, such as providing copies of tax returns or turning over property, the second course is your last step in the case. The court will then issue a discharge within 60 to 90 days after the meeting. You'll receive a copy of the discharge order in the mail from the court. Retain a copy. We will also send you an email when we receive a copy so that you'll be notified that way as well. Great. So now we've covered everything associated with the 341 meeting. We've covered who's involved, what to wear, what to bring with you, how the meeting is conducted, and what happens after the 341 meeting. If you follow these instructions, particularly with the documents to bring and have them out and available and in the right order, your 341 meeting should run smoothly and you'll be much more relaxed. We look forward to seeing you then.